So here we are. We are on our last chapter as it relates to the courts block. Now, I hope that you have found these lectures enjoyable. I've decided to whip out I don't want to say costume, but I've tried to dress up some, and I don't get to do this as often. Sometimes in my in-person classes, I will wear a shirt and tie, and I've had students be like, Professor Fields, what's the occasion? Are you looking spiffy? But dressing up in a shirt and tie was a common occurrence every day for me, whether it was occasionally at my time in law enforcement or certainly when I was a probation officer. So anyways, we are going to conclude this block or module on the courts. Remember, the courts are our second primary component of the criminal justice system. And this chapter, chapter 9, is going to focus on the criminal trial and sentencing. So we've started talking about the courts and the judiciary in chapter 7. Chapter 8, we focus on prosecution, defense, and pretrial activities. And now we want to talk about the actual criminal trial itself and what happens at sentencing. So let's get right into it, shall we? Criminal trials are designed to ascertain guilt in those charges with crimes or prove a lack of guilt. So a criminal trial is designed to find out whether a person is guilty or not guilty, but they want to prove guilt or innocence. Having said that, the burden of proof in a criminal trial, is beyond a reasonable doubt. That's a very important standard here, because generally speaking, when looking at courts, a lot of people, and as we focus on the criminal justice system, a lot of people don't understand what a reasonable doubt means. What that means is that the person is 100% has been proven guilty beyond a reasonable doubt. Their actions show unequivocally, unconditionally, and without any other pause that they were the ones who did what they did. So a criminal trial is actually quite rare. And the question is begged, well, why don't more cases go to trial? Well, remember what we talked about in chapter 7? Just to bring back to your remembrance, plea bargaining. Remember what plea bargaining is and what it does. Plea bargaining is the opportunity for a person to plead guilty or no contest, nolo contendere, with the expectation that the case will be resolved, there will be no trial. Well, in this case, we look at two types of guilt that exist. We have legal guilt. Prosecutor is going to persuade a judge or jury that the person is guilty of the criminal charges. And then, of course, we have factual guilt, which is whether the defendant actually committed the crime. In this case, legal guilt and factual guilt make things very murky, simply because it is entirely possible, based on a criminal trial, that a prosecutor can fail to persuade a jury that this person is legally guilty, right? In other words, a factually guilty person can be found legally not guilty. So if Fred over here murdered somebody and we really, really, really think that Fred murdered, but we don't have all the facts, it's very possibly that a factually guilty person, because Fred did murder the person, could be found legally not guilty. On the other hand, a trial can cause a factually innocent person to be found legally guilty. We'll get to that when we get to corrections in starting in the next module or next group, rather. So just understand that legal guilt and factual guilt are two separate ideals. So there's other types of trials. We have civil trials. Civil trials are just a settlement of a dispute between two non-criminal parties. Usually it's like a lawsuit, property issues, family matters, lack of payments. In civil trials, the burden of proof is preponderance of evidence. So essentially, the reasonable doubt standard is, or beyond a reasonable doubt means 100% this person is guilty. This person did this crime, 100%. In the civil trials with preponderance of evidence, it's called the 50+1 standard. In other words, I just have to have just a little bit more people agree with me that you did something to me, that hurt me in this way, wronged me in this way, whatever. As long as I can just have one more person agree with me, that's a wrap. I don't care that there's other people that say, no, you didn't do it. I just need one extra person, 50 plus one, to agree that I should be made whole. We have traffic hearings. If you are listening to me and you've had a traffic offense, and some of you have, and I've had students who've had traffic offenses, gotten tickets, whatever, understand that a traffic hearing is not a criminal trial. It may feel like a criminal trial, but it's not a criminal trial. If you're speeding, if you have no license, you have no insurance, no registration, like all of those are traffic offenses that can result in a traffic hearing. And then there's also bench trials and jury trials. With a bench trial, the judge is the fact finder instead of the jury. So the judge listens to everything and then makes the decision. Jury trial is where the jury will listen to the facts and then they will render a verdict. So I just wanted to show you that there's other types of trials besides a criminal trial: civil trials, traffic hearings, bench trials, jury trials, etc. And a criminal trial and a jury trial are essentially one and the same. It's just in this instance, the jury trial is focused on that the jury is a fact finder. And usually you'll find a jury trial in a criminal trial, or you can find a jury trial in a civil trial as well. So how do cases work? Well, just like you see me here with my suit jacket, and I got my tie on. I also decided to include this pen. I should have included this the other day, but this is a gavel. I ran a program called Teen Court. When I left law enforcement, I was the coordinator, the program coordinator, essentially the administrator over that program. And so we had some of these leftover pens, and I said, well, I want to take one as a nice keepsake. When looking at criminal trial, understand that the prosecutor has the burden of proof to prove their case and not the defense. Why is this important? Because defendants are innocent until proven guilty. What this simply means, folks, is that as a defendant, you don't even have to say anything. A defendant invoking their Fifth Amendment, and we talked about constitutional amendments way back in the law enforcement chapters. The Fifth Amendment protects a person against self-incrimination, right? If you say, I plead the Fifth, that is not an indicator of guilt. But what happens? We often associate silence equals guilt. Silence equals guilt. And people don't understand how our criminal justice system works. You all, after this class, are going to have a better understanding than about 75% of the population. Picture that. Professor Fields is telling you just by taking this introduction to criminal justice class. Some of you may never take another criminal justice class in your life. Others of you might be like, hey, I kind of want to take one more here or there. Just by virtue of taking my class, you're going to have a better understanding than 75% of the population just off of this class. So people don't understand that a defendant doesn't have to say anything. They are innocent until proven guilty. Innocent until proven guilty. And yet, oftentimes, we equate silence or them not talking as guilt. And it's wrong. It's wrong. So, opening statements, what happened? The prosecutor and the defense are offering opening statements on what the other side is going to show. It's not evidence, but it's a prediction of what will be presented at trial. Now, because I talked about, or because it was just mentioned in the previous side that evidence must be relevant, it has to be material, and it has to be competent, we have to know and see that evidence is broken into two major classifications. You have your direct evidence and you have your circumstantial evidence. Now, with direct evidence, doesn't require a fact finder to draw an inference. Clear direct evidence is you have a video showing the person committing the crime. Now, people can say, well, that wasn't me, that was my brother. Pfft, come on, get out of here. That wasn't me, that was my twin. Yeah, right, you don't have a twin. But generally speaking, a video showing a crime being committed, It doesn't get more directed than that, right? It's easy and you can't overlook it. Then we have circumstantial evidence. This requires interpretation of evidence by a judge or jury. So fingerprints found at the scene of a crime, even though a person said they were in another state or city or town, yeah. Can we argue that their fingerprints would be there because the day of the incident they were at that home, that's their residence, and they left that day? And yes, we can see their plane ticket and we can see the video, and we can even do a TSA confirmation to show that they were screened in an airport. Can we do that? So that's circumstantial evidence. And then, of course, within direct and circumstantial evidence, we also have this thing called hearsay. And so hearsay is just an out-of-court statement offered in court to prove the truth. There are some exceptions to the hearsay rule. So first of all, hearsay has some different exceptions, and here are some of the notable ones. There's 30 exceptions, but here are some of the notable ones. The dying declaration. Final words of a crime witness may be used in court. If you arrived on a scene and you saw someone brutally stabbed, and you were like, who did this? Who did this? You know, it was Ken. Well, we don't know Ken's last name, but we know this person's name is Ken. And then eventually, through the investigation and the rabbit hole of trying to find out what happened to this victim, you find out that there is a suspect whose name is Ken. That dying declaration holds up in court, absolutely. Excited utterance, words blurted out under stress or excitement, and then reputation concerning character may testify about a social reputation. So those are hearsay, or some of the examples to hearsay. What about closing arguments? The prosecutor goes first, the defense attorney, and then the prosecutor. Why is that? The burden of proof is on the prosecutor, right? The prosecutor has to present their case beyond a reasonable doubt. They have to invoke that. There is no shadow of doubt. There is no reasonable doubt here. This defendant over there was the one responsible for the offense. So that's why it's prosecutor, defense, prosecutor. Now, some would argue, well, because we're in an adversarial system, which is what I talked about in Chapter 7, it's not fair that the prosecutor gets to go, the defense goes, and then the prosecutor gets the last word. But the prosecutor also has the burden of proof on them. The defense attorney and the defendant don't have to do anything. They could sit back and say, we're just going to sit here, listen to what people say, object to comments, and do nothing, because the prosecutor has to put the work here, proving that this individual accused is the one who did the crime. Now, there's the thing called rebuttal, and that's where prosecutors get the last opportunity to speak. But understand, closing arguments are not mandatory. Once a case is rested, that's it. So you can't say, you know what, the defense rests, and then the prosecution's like, well, Your Honor, we still have several more questions, several more witnesses. And then you're like, wait a minute, that's not fair. We rested, you should rest too. Well, never mind. We're unresting. No, when you rest, that's a wrap. So what is the judge's charge to the jury? Typically, the judge will instruct the jury on the legal aspects of reaching a verdict. In fact, the judge will argue that all you can consider is the law. So I thought I left this in my office on campus, but I just so happened to still have a copy of my Georgia Criminal and Traffic Law Manual from the 2021 to 2022 edition. So it's a little outdated, but I would get this every year as being a probation officer. I think the last year I got was the 2024, 2025, or I got 2023, 2024. I think that was the last one I got. But either way, it's really something that you see this thick book. This is a thick book. I mean, we got over 1,800 pages of laws, Georgia laws. And typically what will happen is when a judge is instructing a jury on the legal aspects, don't be surprised if a judge holds up a manual like this and say, you can only consider the law, which is what we have in this book here. That's all you can consider. You can't consider phantom evidence. You can't consider, hunches and conspiracy theories. You can only consider the law, and the law is what's found in this book, right? So again, we'll remind people, you're innocent until proven guilty. The state had to show their case beyond a reasonable doubt. You have to dispute facts as well as relevant law, and you must be objective. Only consider evidence that is presented. So the jury will go ahead and deliberate. Typically, this process is determining guilt, takes place outside of the courtroom. It's usually in a hidden part of the courthouse. And during deliberation, the jury will typically be sequestered, meaning they have to be isolated to prevent outside influences. Now, like I was telling you all in the last chapter, with the trial of the Bad Boy Records CEO that's going on in New York right now, as I'm doing this lecture, understand that jury is absolutely sequestered. When they broke over the long Memorial Day weekend, the judge reminded them, do not look at the news, do not look at the media, and do not talk to anybody about this case. Now, can the judge enforce that 24/7? Absolutely not. Unless he's going to place a NYPD police officer or someone with New York, like with each jury member around the clock, you can't stop conversations. However, you want to do the best you can to limit outside influences from affecting the jury. And so at this point, while the jury is sequestered, they will finally make the determination on what their decision is going to be in the trial. And then the foreperson is chosen, which is the de facto spokesperson of the jury. And he or she will advise whether or not they've reached a unanimous verdict. And a unanimous verdict means all 12 jurors must be on the same page. You can't say, I think this person's guilty, and then chicken out and say, no, they're not guilty. And then when they say, well, what happened? And you say, well, I always thought they were not guilty. I just went along with saying they were guilty because I wanted to get this done. You're going to get into a lot of trouble and get a lashing from the judge. If the jury is what's called deadlocked, meaning they could not agree on guilt or innocence, then that's when you have what's called a hung jury. And typically when you hit a hung jury, now all of a sudden there's frustration on really the side of the prosecutor, because now they have to make a decision to try the case again. With the mistrial, the trial ends without a normal conclusion. Well, the defendant might like that, because depending on the circumstances, the defendant might go free, or depending on the circumstances, the defendant may just stay in jail, let's say if other charges are coming, right? But most of the time, the defendant will go free. So in terms of reading the verdict, when you read the verdict, the formal courtroom event is when the jury offers their verdict on the charges. First of all, a person can be acquitted. In other words, a person can be free from criminal charge, and this is when they're free due to a not guilty verdict. Once they're acquitted, they can't be retried by the same prosecutorial jurisdiction. So even if you have new evidence that may point to their guilt, they cannot be tried again by the same prosecutorial jurisdiction. There's two videos out there. One is of a famous football player back in the 90s who was tried for the death of his wife and her friend. You got jubilation on one side when he was acquitted, right? The other side, you have a video which shows at the time, 17-year-old individual from Antioch, I want to say Illinois, but he was from out of state. He shows up in Kenosha, Wisconsin, and he's trying to help diffuse some of the protests because of the shooting of a unarmed man. And for that person, he also had jubilee, but there was anguish on behalf of the victims there. So understand that acquittal will invoke a reaction from two separate sides. Now, being tried again for the same charge is known as double jeopardy. Prosecutor can't charge you again if you're acquitted. There are some exceptions, although very rare, but generally speaking, as you see, some of the exceptions include if there's same facts but different elements of the crime, if it's a different jurisdiction, like you beat charges at the federal level or the state level, but you have to deal with the feds, sometimes being tried in civil court after having been tried in criminal court. But again, double jeopardy is very rare. If you are acquitted, that's it. And as you can see from the person right here on the screen, they were sharing that emotion because they were acquitted. So let's talk about sentencing. Sentencing is the application of a criminal sanction against a legally guilty person. There's three principles of punishment. Punishment should be proportional, have equity, and focus on a social debt. When we look at proportionality, it's the severity of sentence has to match the crime. When we think about the equity, similar crimes should be punished similarly. Think about precedent, what we talked about. And then lastly, social debt. It counts for a criminal past in sentencing. Now, there's 5 primary goals of sentencing and punishment. The first is retribution, getting revenge, getting even, eye for an eye. You did something to me, I'm getting even. I'm not going to get mad, I'm going to get even. We have incapacitation, the notion that offenders are not going to commit new crimes because they're incarcerated, they're locked away. Deterrence. Deterrence dissuades offenders and others from crime. We have general and specific deterrence. General deterrence deals with you and I. We know if we break the law, we can go to jail. That's why we don't break the law. Specific deterrence deals with the people who have constant criminal offenses and they're never going to get better. They're not going to stop engaging in criminal behavior. We also have rehabilitation. That's where you treat a person, right? You see them as sick and they need treatment, and through rehabilitation, the goal is to provide them with services. It could be problem-solving courts we talked about. It could be counseling. It could be other services. And then reintegration is our last one. That's where the person goes back into the community after they completed their sentence. So you could have what's called a pre-sentence investigation. All this is just a report in which the judge, the prosecutor, defense attorney, they review some key demographic history on the offender. And the PSI, as it's called, is very helpful because the PSI determines whether or not this person might even be a candidate for community supervisions or no. We need to lock this person up very, very badly and desperately. So the PSI is a great snapshot and a great tool because it gives key information about an offender, where they work, where they went to school, why they are doing drugs, have they passed the drug screen, are they working, what else that could go in there. But it's stuff that could be very good or very, very damaging. So we have an indeterminate sentence. This is where a person's is sentenced and they don't have an actual number of years, but they have a range of years. So you might be in prison for between 2 and 5 years. So hopefully you're coming out closer to the 2-year mark, but you don't know. So that's an indeterminate sentence. You might get 2, you might get 10, but you don't know. On the other side, when looking at indeterminate sentencing, that does give a greater discretion to craft individualized sentencing because you can really focus on rehabilitation. Hey, we're going to potentially release you in, we're going to potentially release you on XYZ date, but we want you to really focus on rehabilitation. Hopefully, because you now know that what your potential release date is, you will be more keen and more locked into engaging in rehabilitation or therapy or treatment. Then we have the structured sentence. These are when sentences are generally given in the form of fixed terms, has an anticipated release date. They do have some elements of indeterminate sentencing, such as limited parole and good time served, but this is a structured sentence. Now, what I was getting ready to say and get into is the determinate sentence. This means that a convicted individual is more likely to be given a fixed number of years, and they have to serve, serve their time under this particular sentence. They don't get out early, right? This is how punishment is designed to deter people who commit the same crime and maybe received a different sentence. Now, yes, generally speaking, longer and more determinate sentences satisfy the urge for greater punishment for offenders and serve an incapacitation function. If you know that I do this and my sentence is going to be 20 years automatically, then I can't act surprised when I hear we're offering, you know, we're offering this particular time. Like you can't have that, right? So understand that you know what a determinate sentence is. You know the number of years you're going to have other than the range that you would have in an indeterminate sentence. And then the last one is the mandatory sentence. And these are called mandatory minimums. And we're going to get to mandatory minimums in a minute to kind of wrap up this lecture. But mandatory minimums, they could be concurrent, meaning it's served at the same time, or consecutive, meaning it's served sequentially. Mandatory minimums are based on a lot of factors. The judge, how serious the crime is, the criminal history, plea bargaining, if they're willing to cooperate, and only when it comes to mandatory minimums, the main person that's going to impose it is the judge, but who's going to argue for it? A prosecutor or state attorney or district attorney. They're going to be the ones that are going to heavily argue for mandatory minimum sentencing, especially because they have the ability to look at an individual's, criminal history and whether or not doing the same thing over and over was effective. And if it wasn't, then they may be saying, hey, that person needs to go into some type of incarceration or lockup to recognize that this is not a game. This is very, very serious. So some of the states that I'm going to talk about have some form of a habitual offender statute. For example, the most notable one, which was birthed out of California, was 3 strikes and you're out, right? 3 strikes and you're out was a no-nonsense expansion of mandatory minimums, where if an individual got their 3rd conviction, whether it was a misdemeanor or not, they would go to prison for life. That's why it was called 3 strikes and you're out. Well, Florida has something called 10-20 life. As you see, you pull a gun, you get 10 years, you shoot the gun, just shoot it, don't even hit anybody. It's 20 years. If you actually hit them, it's 25 to life. Very, very strict, right? Georgia has 7 deadly sins, and you can see what those deadly sins are. So if a person commits any one of these crimes and they have or don't have criminal history, the state could be working out a plea deal. Instead of giving them 10 years in prison, they may just give them, I don't know, maybe they'll give them 3, or maybe they'll give them 5, right? But generally speaking, when it comes to the 7 deadly sins, the minimum amount of time someone's looking at is 10 years in prison. And then we have the Alabama 1979 Habitual Felony Offender Act. It mandates life imprisonment without parole for persons convicted of a Class A felony after having previously been convicted of any 3 felonies. And what are Class A felonies? Well, you see what they are. First-degree burglary, arson, offering drugs to anyone under age of 18. So these are very serious because just like with Georgia and certainly Florida, if you get one of these convictions, you're probably going to have a very difficult time maintaining and functioning in life. And if certainly with that 3rd conviction, you will go to prison for the rest of your life. You don't get any benefit of the doubt. So when it comes to diversity in sentencing, many people have argued that diversity matters in terms of, what is the genetic or social makeup of people who are getting sentenced. And, as you can see, even though this is old data, 86.8% were male, 48.6% were Hispanic males. Many have less than a high school diploma. Others have just a little bit of high school information, or a little bit of high school, education rather. So special criminal trials, you get your capital cases. Usually with a capital case, it's a serious charge: premeditated or first-degree murder, treason, murder of federal agents, murder against judges, murder against politicians, some hate crimes against children. But that is a capital case, it's a first degree murder case. So, yeah. Again, juries are more likely to be sequestered. The reason for sequestering a jury is because you don't want jury members talking about it. You don't want them blowing up Facebook or posting about things. And if they do, they could face a serious and significant penalty. But generally speaking, once that jury gives a unanimous verdict, many defense attorneys say it's okay because we already were going to, we were already going to appeal. And this mandatory appeals process is always found when it comes to capital cases or murder. And so last thing is just, what is the public opinion on the death penalty? In terms of supporting it, based on some old data, 55% are in favor of the death penalty if they were convicted of murder. But these are historic lows. Like, these numbers will be higher and higher than what they were. And it just shows that young people and Americans in general are saying we're sick and tired of supporting all this death. So with that being said, why do people argue someone should get the death penalty? For one, they think this person won't reoffend. They think it focuses on general deterrence. In other words, you and I won't offend. And some just say it's just a quick and easy moral response to the actions of an individual convicted of murder or other brutal crimes. Now, the arguments against the death penalty, first of all, some people are against it. They are contractually or they're morally inconsistent with it. Others say that an innocent person could be executed, and yet others have felt like there needs to be more research to support general deterrence as an effect. Okay? So if we ask the question, does a capital case or being on death row, does it violate our Eighth Amendment? And it doesn't. Because we're not going to have our Eighth Amendment compromised because we're going to death. We can argue in some cases maybe it's cruel and unusual punishment, but in other instances we have to denote the fact that our laws are our laws. And our laws stated it is okay to execute a person who has been found guilty and ultimately is sentenced to Skid Row. Or is ultimately sentenced to death row. And so lastly, in terms of victims of crime in the criminal trial, to maximize the success of convicting an offender, there's initial actions of the victim are critical. The victim is always going to play a key role in the investigation. They're going to talk about what happened. They're going to talk about what the circumstances were surrounding their victimization. And so having the victim be present in the process is very important. Certainly it can be scary testifying. If you've never been in a courtroom setting, some people might be like, oh, cool, this is awesome. But for other people, they might be like, I'm kind of scared. I don't know how I'm going to respond or how I'm going to act here. Either way, you have to have the victim present, because if you don't have the victim cooperating, your case is going to be sunk before it gets started, right? You might have enough evidence to still maintain a conviction, but a victim that has been affected by this individual, that's the defendant and sitting over here, can't beat that. You cannot beat that. And that's where victim impact statements help, and certainly being able to tell your truth and how this victimization affected you will absolutely guarantee that you are being heard. With understanding how victims operate, and certainly in the criminal justice system, this Victim Bill of Rights is going to offer similar rights to crime victims on a state level. The Victim Bill of Rights gives victims a number of protections. They have the right to be heard. They have the right to be notified of a court hearing. They have the right to be protected from the accused or protected against any retaliation. They have the right to not be excluded from any such public court hearing. So, in other words, they'll always be notified about court and they can certainly participate. But these victim bill of rights are absolutely, absolutely pivotal and vital. It's important for them to be able to talk to an attorney about the case. It's important for them to get restitution. It's important for them to be treated with fairness and with respect, because their dignity and privacy and being victimized is certainly front and center. So I know this was a very long chapter, but this is the conclusion of us talking about the courts, right? Within this chapter, understanding criminal trial, understanding sentencing, it is important to know that as we looked at the judiciary, judges, we looked at attorneys, prosecution and defense, and we even talked about some pretrial activities. The trial itself is where it's at. Not every case is going to trial. Again, about 80%, 90% of all cases are settled through plea bargaining. But please recognize and look at the fact that we do have trials in this country. We do have many people that go to trial. We have a famous trial going on in New York right now. Even said person, even that bad boy record CEO, is presumed innocent until proven guilty. That is the standard in a criminal case. If we were in a civil trial, it's the preponderance of evidence. And remember, when you have juries and you have individuals who are attorneys, they need to know this book like the back of their hand. Now, they're not going to remember everything verbatim, although some lawyers are just that good. But for the most part, attorneys will have their criminal and traffic law manual that they can consult with before cases, and they can certainly look at this book even during a case. So I want to thank you for tuning in. Thank you for taking this journey with me on our third module, which focuses on the courts. Next time we come back, we will jump into our final module, which focuses on that last component of the criminal justice system, corrections. But take care, stay safe, and I will see you next time.